A very good day. My name is Hati Muhammad, matrix number 2959848. So, I would like to go through a simple introduction. The climate crisis is fundamentally a crisis of right. We must integrate a climate justice and integration right. The core problem is a failure of intergenerational equity. Our current unsustainable practice driven by a short-term gain are unfairly placing a massive instability and additional risk to our children and grandchildren. For Malaysia, there is no abstract. As a coastal nation, we face immediate threats from sea level rise and extreme weather. Furthermore, climate justice is crucial to address the disproportionate impact of environmental degradation on our indigenous or asli community. Therefore, effective global governance demands a right-based framework. By enforcing both climate justice and integration rights, we establish the ethical mandate needed to secure a sustainable and equitable for all future, now and in the future. Thank you.
Hi and Assalamualaikum. My name is Nonizarina Atira 295442. I'll be presenting on the application of historical theory to climate justice and intergenerational rights. Historical theory sees law not as invention but as evolution, a living thread woven from ancestral custom, doctrinal legacies, and societal continuity. It offers two phases, one that honors indigenous stewardship and ecological guardianship, another that clings to colonial property regimes, obstructing sustainability and silencing the rights of the unborn. Malaysia's indigenous community, a living legacy. Orang asli land rights reflect deep traditions of caring for forests and rivers, not as property but as sacred trust. These practices embody both intergenerational responsibility and climate justice, yet colonial era laws still dominate, sidelining other and weakening indigenous conservation rules. Malaysian courts have the chance to evolve historical theory by integrating adat into environmental rulings, aligning tradition with sustainability and protecting the unborn. In New Zealand, the Wangani River was granted legal personhood honoring Maori guardianship and setting a global precedent for environmental rights. In contrast, India's Supreme Court ordered mass evictions under colonial land rules, ignoring tribal stewardship and exposing how rigid legal frameworks can clash with climate justice and human rights. In the Philippines, the case of Oposa saw children sue to protect forests for future generations. The court recognized their standing as guardians of the unborn, showing how historical theory can serve intergenerational justice. In the United States, land doctrines like the Homestead Act's privilege present exploitation over sustainability, rooted in entitlement. They reveal how history can block progress when law fails to evolve. So, does historical theory protect tomorrow or merely preserve yesterday? This question captures the tension between tradition and progress. Historical theory sees law as inherited, shaped by custom and continuity, but inheritance can either empower future generations or entrench outdated norms. In conclusion, historical jurisprudence must move beyond colonial land legacies and grow into a living framework that honors indigenous stewardship, protects ecosystems, and carries responsibility across generations. By reshaping precedent into sustainability and guardianship, courts can ensure that law speaks not only for today's communities but also for the unborn, weaving ancestral wisdom into modern climate justice.
Assalamualaikum and a very good day. My name is Nurin Azrina Sambai binti Norizam with matrix number 294731, and I will continue our presentation on the sociological theory in application to climate justice and intergenerational right. So, according to Bentham theory, sociological theory push that law represent the majority interest and law should reflect what benefit people the most and not just a few. So, sociological theory reveals that law evolved with the society morals expectations. Applying this theory to the climate justice, as according to the case of Urgenda Foundation and Netherlands in 2019, the court held that the court recognized the Urgenda's claim under the Article 2 and Article 8 of ECHR, which protects the right to life, and the court recognized that the Dutch government has an obligation to protect these rights from the real threat of climate change. The Malaysian government has also adopted the climate justice rights in Malaysia, and we will see how the society shapes the law in Malaysia, where in Sabah, the government has passed a climate change and carbon governance enactment in 2025, which recognized the carbon rights and also in the same time gives legal protection to the indigenous landowners in Malaysia, in Sabah itself, applying the sociological theory in intergenerational rights. So in the case of Future Generation and Ministry of Environmentals and others, the youth has claimed their rights for their future right of healthy environment, life, health, food and water. So the sociological theory protects the future of generation because the theory recognizes that law is embedded in social relation, highlight the social morals obligation extend beyond the present, which is mean that the future also have the right to life. So the mechanism to protect the intergenerational rights is firstly there must be a social pressure, secondly changes in the legal institution which is the court and also the government, and also adaptation to common values of the society itself. In summary, both climate justice and intergenerational rights are deeply rooted in social rights which must incorporate both the people need at large. So in shaping the law, the sociological theory adapts to the changes in social needs while also balancing with the preservation of the future.
Hello everyone, my name is Theo Yiwen, metric number 294622. I will be explaining how legal realisms apply to climate justice and intergenerations right. Legal realisms is the idea that law is not just what is written in statutes or textbook, which we call law in book. Instead, what truly matters is law in action, meaning how just governments and institutions actually apply the law in real life. According to legal realism, just decisions are influenced by real-world factors such as social need, economic pressure, political interest, and cultural value. Now, how does this help us understand climate justice? First, legal realism as an enabler. In climate-related cases, the court can look beyond the strict legal rule and focus on real human impact. A good example in 2024, Malaysia High Court case involving the Sermais indigenous community in Perak. The court stopped the hydroelectric dam project because it recognized the real consequence of the Sermais people, which are loss of the lands, cultural harm, and lack of concerns. This shows legal realism supporting climate justice by highlighting the lived realities of its former approval. Second, legal realism as an obstacle. Legal realism also explains why climate justice is sometimes not achieved. Even if environmental protection is written in the law, the governments may prioritize the economic development, public interest, or infrastructural projects. For example, in the year of 2025, Kampong Jaya case, 19 landowners was ordered to vacate their lands to allow the construction of the highway company. These decisions reflect the real-world pressure like development needs rather than ideal environmental principle. So, legal realism helps us to see that climate justice depends not only on what the law says, but on how decisions make balance social realities, government interests, and community needs in practice. Now, let's look at the legal realism applies to intergenerational rights, the future generations. First, legal realism as a protector is focused on the social purpose of law and the practical realistic of society. This allows the court to interpret the law in ways that protects the people who cannot speak for themselves, such as future generations. Because the future generations have no voice, courts may allow the youth groups, NGO, or the public interest individuals to act on their behalf. A famous example is in 1993 case of Midos Oposa versus Victorians in Philippines. Anthony represented children and future generations to stop the destructive logging. This court accepts that the current generations has the duty to protect the environment for future generations. This shows how the legal realisms can expand protections by focusing on the real harms rather than strict procedural limits. Next, legal realism as an obstacle. Even though the idea of protecting future generations sounds ideal and good, however, legal realism reminds us that the real world focus often limits this protection. Government and court may prioritize short-term economic need, industrial developments, or infrastructure projects, even when they conflict with the long-term sustainability. A good illustration is the case of Semantan Estates versus Governments of Malaysia. Although the land dispute dates back decades, the states prioritize the public purpose such as road construction. This shows how in practice court may put economic growth and development ahead of the long-term environmental or intergenerational considerations. So in conclusion, legal realism shows us that the protecting intergenerational right is possible but challenging. Well, the court can expand the standing for future generations, political pressures, economic demands, and immediate public interest often limits how far these protections go in real life.